So a lot has happened since I dropped the video about the Texas anti-trans or anti-gender affirming care for children directive. It was intended to be a binding directive or to appear like it's a binding directive, but in reality, the directive wasn't really a binding opinion that could be enforced in law, but Greg Abbott and Ken Paxton really wanted it to be. When we last left this story, Judge Amy Clark Meekum of Travis County, Texas, not a federal district court, but a state or county court, Travis County, Texas, had issued a temporary restraining order directed solely at the parties in the lawsuit. So the story now is that the judge has expanded that order after a hearing on Friday, and now that order prevents all enforcement of the Texas anti-trans directive against all state agencies and state actors in the state of Texas. Let's take a look at a story by the Associated Press. It starts, Texas judge blocks investigations of trans youth parents. A Texas judge on Friday blocked the state from investigating as child abuse gender-confirming care for transgender youth. District Judge Amy Clark Meekum issued a temporary injunction preventing the state from enforcing Governor Greg Abbott's directive to compel the Department of Family and Protective Services to investigate reports of youth receiving such care. The injunction broadens Meecham's earlier order blocking the state's investigation of parents of one transgender teenager. Now, what I don't have is a copy of the order, and if I can find a copy of the order, I will share it either here or in another video. But for now, what we do have is news reports of the broadening of the order, as well as the result of Ken Paxton's appeal. Ken Paxton had appealed to the 3rd District Texas Court of Appeals, again, a state court. Appellees, which is the DOE parties, the plaintiffs in the temporary restraining order, appellees have filed an emergency motion to dismiss the appeal for want or lack of jurisdiction. We will grant the motion. This appeal arises out of a dispute over the legality of providing gender-affirming health care to children. Now might be a good time to go over this, because I see a lot of misconceptions about what gender-affirming care for children means. If you were to believe the detractors, the contrarians, gender-affirming care means that a child decides one day that they are not the gender they were born with, and then they immediately go for surgical alteration of their person. That is not what happens. Surgical alteration does not happen until someone is older, generally above the age of consent and usually above the age of 18. What is happening with gender-affirming care first is a long medical evaluation over a period of years before there is any sort of medical intervention. And when there is a medical intervention, it is a discussion between the doctors, the psychologists, the parents, and the child, usually over a long period of time, to the best of my understanding. And then, if necessary, if medical professionals believe that it is the best option, there is something called a puberty blocking drug that delays the onset of puberty while a child can decide for themselves and their doctors how they want to proceed with treatment for gender dysphoria or whatever their gender issue is. No one makes these decisions lightly. No one pushes their kids to change their gender against their will. None of this happens quickly. None of this happens with surgical alteration. And if you were to believe the detractors and contrarians, you would think that parents were forcing things upon their children that are life-altering, permanently damaging, unnecessary, part of a phase that will simply pass, and that all of this is child abuse. I guarantee you myself, but you can also find this with your own research, that that's not what's happening. As evidenced by the response to my earlier video, a lot of this misinformation was being spread before anyone even knew what Mary Doe's condition was, before they could have watched the video and seen what was going on. So take that for what you will. That's been the reaction. On February 22nd, 2022, Governor Abbott sent a letter to Commissioner Masters enclosing an Attorney General opinion determining that certain types of gender-affirming care might constitute child abuse. He directed the department to investigate any reports of children receiving those types of treatments. This is effectively a government order that someone receiving medical care is automatically on suspicion of child abuse. So if a parent or doctor has provided any gender-affirming care, then they deserve to be investigated by the government. You don't get this for other health conditions. If someone breaks an arm, it doesn't mean that there's a Child Protective Services investigation, assuming that they are abusing the child. But yes, under some circumstances, you might get an investigation when you find out that the child broke their arm by being shoved down the stairs by a parent. But that's not what's happening here. This is a blanket order that, without any further evidence, without any circumstances showing child abuse, we're going to treat transgender or gender-affirming care as child abuse. And that's unacceptable. That is a violation of the constitutional right to life, liberty, and happiness without due process of law. In other words, the government cannot take away your right to life, liberty, and happiness, your freedom of speech, your freedom of association, your freedom to go visit a doctor and get appropriate medical care without due process of law. Now, detractors and contrarians may say that it's just an investigation. The investigation hasn't found child abuse. But when you read about the testimony that was given on Friday, March 11th, the normal procedure was altered. And instead of investigators using their judgment on whether a report is founded or not, for instance, they have the ability to mark a file or report as not suspicious or not a priority. Instead, they were directed by Family Protective Services and Child Protective Services. They were directed to conduct the investigation no matter how unfounded they thought the report was. And doctors were also required to report this kind of gender-affirming care, which means that gender dysphoria patients can no longer go to the doctor knowing that their confidentiality would be protected. Instead, anyone who reported gender dysphoria and received treatment for it would be required to be reported to the government for investigation, and Child Protective Services would be required to investigate the alleged child abuse of that person. That's what makes it a violation of your due process rights. At Belize, the parents of a transgender child received gender-affirming care, and a psychologist who treats transgender children sued the state parties seeking declaratory and injunctive relief. On March 2nd, the district court granted a temporary restraining order enjoining the state parties from taking any action against the plaintiffs, only the plaintiffs, based solely on the governor's letter or the attorney general's opinion. So the state parties, Abbott and Paxton and the Department of Family Protective Services, they filed a challenge to jurisdiction apparently minutes before the hearing on the temporary restraining order, and the court did not rule on a jurisdictional issue, nor did it reach the merits of the case. A temporary restraining order is instead meant to bring the parties back to the status quo ante, which is the status of the situation before the challenged order was issued, before the directive telling the Department of Family and Protective Services to pursue gender-affirming care as child abuse. So a temporary restraining order does not actually reach the merits, and therefore is not appealable as if it did reach the merits. And the jurisdictional argument was not appealable because it has not been ruled upon yet which will come later. So then came the Friday hearing. Some of the testimony on Friday's hearing: Abbott's directive singles out these families for targeted scrutiny. It stigmatizes them, it invades their privacy, and it interferes with the fundamental right of parents to make the decision of what's best for their child, says Paul Castillo, senior counsel for Lambda Legal. Megan Mooney, the psychologist in the case, testified, parents are terrified that Child Protective Services is going to come and question their children or take them away. Mental health professionals are scared that we're either violating our standards of professional codes of conduct or in violation of the law. Other testimony the court heard was that Child Protective Services investigators were told that they cannot mark a investigation as priority 0 or low priority or no priority, which is something they normally can do when they receive unfounded reports, that every case has to be investigated. And then as a result of that hearing, the judge broadened the temporary restraining order into a temporary injunction, preventing the enforcement of Abbott and Paxton's directive statewide. So now Department of Family Protective Services, Child Protective Services, Abbott and Paxton cannot order the investigation of gender-affirming care for children statewide, except shortly after the judge's ruling, Texas Attorney General Ken Paxton said he was appealing the temporary injunction, halting the abuse investigations into transgender youth. Remember, we just read from the court that you can't appeal a temporary restraining order, but you can appeal a temporary injunction. Now it's a temporary injunction, and now it's appealable. He says that his appeal will allow the state to continue its investigations, effectively reversing the injunction. Ken Paxton tweets, Democrat judge tries to halt legal and necessary investigations into those trying to abuse our kids through trans surgeries. No, that's not happening. And prescription drugs. I'm appealing. I'll win this fight to protect our Texas children. My appeal is now on file. Thankfully, Democrat judge's order permitting child abuse is frozen. Much needed investigations proceed as they should. This fight will continue up to the Supreme Court. I'm ready for it. When you appeal a temporary injunction, that usually doesn't mean that the temporary injunction is frozen. You have to ask the higher court, the appellate court, to issue a stay. Maybe there is an automatic stay while the court has a chance to review the appeal in Texas. But usually there is no automatic stay. The automatic stay is usually quite a rare thing, and the injunction instead will remain in place until the appeals court rules on the appeal. It certainly could be a quick appeal. It could be something where the appeals court is ready, sees this as an emergency or urgent issue that needs ruling. But usually you can't appeal and get a stay automatically. You have to appeal, motion for a stay, and then get a ruling staying the lower court's appeal. I'm interested to see if someone has a copy of the order staying the temporary injunction, because absent such an order, I don't know of any law that grants an automatic stay. A lawyer for plaintiffs who sued to halt the abuse investigation tells me this morning that they don't think there's any basis for Paxton's appeal. There isn't a copy of the notice of appeal or an actual appeal brief online yet. CPS has declined to answer our questions about how the pending litigation will affect their abuse investigations, but if we take Paxton, who doesn't lead the Department of Family Protective Services, at his word, he'll urge the agency to keep investigating trans kids as the appeals process continues. The state's lawyers have argued, 1, the judge who issued the injunction has no authority to do so, and 2, the state can't be sued over this, sovereign immunity. No, usually the state can be sued over things the state does that are outside of the state's power. The state has already lost in the appeals court once before. Paxton will likely take these same arguments to the Supreme Court of Texas. That said, Paxton's public statements have contradicted what the state's lawyers have been saying in court. The biggest contrast: in court, an assistant attorney general argued the state doesn't think gender-affirming care is abuse by default. That's definitely contrary to what Attorney General Ken Paxton has said. He thinks that transgender care is somehow child abuse. I'm not saying that a transgender child couldn't be abused just like any other child, but a child with gender dysphoria, that doesn't mean that the child is automatically being abused. Should Child Protective Services investigate allegations of abuse? Yes, they should. That's their job. We want to protect children. Should they investigate as child abuse, gender-affirming care that is medically authorized, that has been properly evaluated? No. That's going to deter people from seeking care. Child Protective Services should only be investigating abuse allegations that are founded, not abuse allegations that are based on someone receiving authorized medical care. Interesting side note, the state's lawyer who said gender-affirming care is not abuse automatically or per se last week was not in court this week. We don't know why. This is all to say that I wish I could be clearer on what families, doctors, and teachers should expect. We may know more today. In the meantime, here are some stories. And that was from Lauren McGoffey, an investigative reporter for the Dallas News. Is it a HIPAA violation to reveal the gender-affirming care of a patient that comes to a doctor to seek treatment for gender dysphoria? Yes, it probably is. It's an ethical violation of the duty of confidentiality. And that's the problem, is that you have, as a doctor, as a psychologist, you have a duty of confidentiality. And then the state says you must violate that confidentiality in this case of gender dysphoria. If you're a child with gender dysphoria and you seek treatment, that's a reportable situation. So if the doctor then follows the state law, then they're in violation of their duty of confidentiality with their licensing body. If they follow their duty of confidentiality with their licensing body, then they're in violation of a state law and subject to criminal penalties. So you put doctors in an impossible situation. The only way to prevent that situation is to simply not offer care for gender dysphoria. Someone calls you and says, my child is having gender issues. Can we talk to you? And you say no. That's the only way, is to deny care. So to deny medical care without due process of law is a violation of your right to life, liberty, and pursuit of happiness, a violation of your First Amendment rights, freedom of association, and a violation of your Fifth and 14th Amendment rights to due process and equal protection under the law. It's probably some kind of illegal discrimination based on gender as well. Ken Paxton and Greg Abbott had issued an opinion a week before the primary elections. Yes, this probably has to do with showing voters that Paxton and Abbott are tough on gender issues. Many people who are not familiar with transgender issues or gender dysphoria issues, it's something they react poorly to. I don't want to go into saying more about what they believe because it's disgusting and it's short-sighted and it is ignorant. Because the things that Paxton and Abbott say constitute child abuse simply aren't happening the way they're saying. It is simply a fire starter for kindling to fuel a bigger fire. That's what it is. So that's where we're going to leave this story. That's the update on what's happening with the Texas anti-trans or gender-affirming care for children directive. Note that an Arkansas law of a similar nature has already been stayed or had a similar injunction issued at a district court level. I might go over that in a future video. And keep on fighting the good fight, because it's clear to me that this is, as I've said before, an evil attempt to criminalize medical care for a recognized disorder or medical condition. Gender dysphoria has long been recognized by the medical community. There are treatments that are established. They happen over a period of time. No one is going to surgery. No one is sending children to surgery quickly. There is no physical alteration of children by surgical means until they are 18 and no longer children. If someone knows differently, please point to a credible source of information, and I will change my mind, because I live a fact-based life. When I encounter contrary facts, I alter my perception of the world. I don't try to alter the world to fit my perception or my agenda. Let me know what you think in the comments below. And that's today's video. Special thanks to my top supporters in March: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Gutbrodj, Torpedan, ShadowTycho, Earthbound Star, PureMagma, TechTechPotato, Eric Tams, The Blood-Soaked Survivors, and Wyatt Calandro. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.